that period as required by law, neither can the court extend time except the law says so. He relied on the case of PHCN versus Alabi and that of CPC versus Anek and Shetima versus Goni. It is also the submission of counsel that from the pleadings before the Honorable Court, the alleged defamatory publication signed by one Thomas Igalo was published on the 15th day of June 2008, whereas the suit was filed on the 12th day of April 2022. Counsel asked the question, does this action fall within the limitation period for the contract and defamation as clearly provided by law of defamation? Counsel give answer to this poser in the affirmative that the limitation period regulating cases on both actions on contract and tort of defamation being 5 years has already elapsed even before the case was filed on the 12th day of April 2022. Counsel submitted that this suit number NICS/CS/12/2022 filed by the claimant is statute bar, same being instituted after expiry of the period allowed by the limitation law. Counsel asked the court to dismiss the suit for being incompetent. In opposition to the preliminary objection, the claimant filed a written address wherein a single issue was formulated for determination to it, whether having regard to the state of the extant law, particularly in view of the position of the Supreme Court in the case of CPAX Nigeria Limited and others versus MIG4 Nigeria Limited and another, reported in 2018 one Nigeria Ukulele Report, part 1623, page 138. The substantive action as constituted is statute bar. In arguing the sole issue for determination, Uyobon Jonah Esquire counsel for the claimant submitted that the claimant commenced this action timelessly on the second day of December 2010 at the proper forum before the provisions of the third alteration of the Constitution that combat exclusive jurisdiction on this court was enacted. The matter went on appeal and appellate court rendered its decision wherein that the matter is within the exclusive purview of the jurisdiction of the National Industrial Court of Nigeria. It is right law that in consideration as to whether a claim is statute barred or not, the court will have recourse to the writ of summons and statement of claim. Counsel refers to paragraph 25, 26, 27, and 28 of the statement of claim and submitted that the Supreme Court in the case of CPAX versus MIG4 Sufra has created a new regime of limitation of action in Nigeria. The new regime recognized suspension of limitation period for a suit filed at the appropriate registry upon being struck out for want of jurisdiction. The effect of the decision is that when an aggrieved party file an action within the time prescribed by law, such action is not statute bar, as it is not affected by the limitation of limitation law. Counsel asked the court to hold that this action is not statute bar. Counsel for the defendant file another rejoinder to the written address of the claimant in opposition of the notice of preliminary objection. In the written address, counsel submitted that the authority referred is not in all force with the instant suit, while the authority refers to where a particular case is struck out and listed in the instant case relate to a competently different action in another court on the same subject matter. Time can only be frozen in respect of a particular suit from date of filing to when same is determined. The said freezing of the time cannot apply in subsequent action which are brought pursuant to the same course of action in another court as in the instant case. The dependent applicant further argued that the Supreme Court decision in APEC, the decision has held that when a matter is struck out for want of jurisdiction, the striking out finally disposes of the matter on or appeal as the case may be. He referred to Ehua versus Ondo State, INEC. counsel submitted that suit number HC/413/2010 was struck out on the 16th of April 2014 for want of jurisdiction. That being the case, Ehua versus Ondo State SEC is instructive and same has terminated the case. In the instant case being NICN/CS/12/2022 is not in any way linked to HC/413/2010, and the argument that time has frozen is misplaced. It is the submission of counsel that this suit is not pending action, which was initially disposed of, but what is before the court is fresh action. The situation would have been different if the said suit was struck out for other reasons other than want of jurisdiction and was subsequently relisted as on the Kazim versus Heman Supra. It is submitted the life of any matter struck out for want of jurisdiction is terminated, and anything filed thereafter is respect of this matter is a fresh action. He refers to the case of Habib Bank Nigeria Limited versus Logiani Nigeria Limited. There is definitely no contention that this matter is being filed for the first time at the National Industrial Court of Nigeria in year 2022 on a matter whose cause of action arose in 2008. It is of no moment that the claimant went on a prolix in a court that has no jurisdiction to entertain his matter. The persisted on the path of petition by challenging jurisdiction on appeal only to get the same result. He surely cannot at this stage circumvent the law to the advantage, having eaten his cake to the fullest. It is the submission of counsel that suit number NICN/CA/12/2022 does not amount to a pending action referred to and relied upon by the learned counsel in CPAX versus MIG4. Counsel submitted that the cause of action in this matter arose in 2008 as pleaded by the claimant, and this matter having been instituted in 2022 is started by counsel as the court to uphold the preliminary objection and dismiss the case. Court decision. The application of counsel for the defendant under consideration has raised an interesting, though knotty, issue of statute bar in an action on simple contract and in tort. I have considered the argument of counsel and critically examined the state of the law on statute bar on simple contract and tortious liability as contained in section 16 of the limitation law of Cross River State Cap L14 laws of Cross River State 2004. The said provision is impari materia with the provision of section 8.1 of the limitation law of Lagos State considered by the Supreme Court in the case of CPAX Nigeria Limited Supra. The issue of an action being statute bar or is the statute bar or not is a fundamental one to the determination of a case. Once it is established that an action is statute bar, the action comes to an end without more. Indeed, the effect of limitation law is that it removes the right of enforcement of the legal right and judicial reliefs. See the case of PDP versus INEC. See also the case of Wilsons versus Ocean. See also Yare versus National Salaries and Wages and Income Commission. The effect of a limitation law is that legal proceeding cannot be properly or validly instituted after the expiration of the prescribed period. It removes the right of action, leaving the claimant with an unenforceable claim. In other words, any action that is instituted after the period of stipulated or allowed by statute has expired. The right of the injured person to commence the action would have been extinguished by such law. His right of action would be totally barred. See the case of Attorney General of Rivers State versus Attorney General of Bayelsa State. See also CPC versus Yuguda. In considering whether or not an action is statute barred, the court is duty bound to consider the facts of the case as disclosed by the pleadings of the claimant. As can be gleaned from the statement of facts, pleadings of the claimant served the defendant between 17th day of August 2005 to 18th day of April 2008, when he tendered his letter of resignation. However, to his dismay, the defendant caused its human resource group to publish a disparaging memorandum concerning the claimant. By the letter dated 23rd day of May 2008 to the defendant, the claimant demanded for withdrawal of such offensive memoranda, but the defendant refused, neglected, and failed to do so till date. Agreed by the action of the defendant, on the 2nd day of November 2010, the claimant took out a writ of summons in suit number HC/413/2010 before the High Court of Justice of Cross River State, Calabar, against the defendant. The suit was filed at the High Court of Justice before the third alteration to the Constitution, which conferred exclusive jurisdiction on labor matters on this court. After full-blown trial, the trial judge, in his judgments of 16th day of December 2014, struck out suit number HC/413/2010 on ground of lack of jurisdiction as a result of third alteration of the Constitution. Dissatisfied with the striking out of the suit, the claimant appealed to the Court of Appeal Calabar Division in appeal number CA/C/07/2016. On the 16th day of July 2021, the Court of Appeal delivered its judgment upholding the striking out of the suit by the High Court of Cross River State on the ground of lack of jurisdiction. Following the decision of the Court of Appeal, the claimant, by the general form of complaint in suit number NICN/CS/12/2022, dated 12th day of April 2022, and filed on the same date, approached this court to ventilate his grievances and seek remedy for the wrong occasioned to him by the defendant, as the initial suit was struck out by the High Court and affirmed by the Court of Appeal, Calabar Division, on the grounds that the proper court to try the claimant case is the National Industrial Court of Nigeria. From the salient facts of this case, as disclosed by the pleading of the claimant, the issues that need to be resolved revolves around the question of cessation or closing of period of limitation, as provided in Section 16 of the Limitation Law of Cross River State, Cross River State 2004. The defendant, in his preliminary objection and the argument canvassed in the written address in support of the motion on notice, or in support of the notice of preliminary objection, and the rejoinder of the claimant's written address filed in opposition to the notice of preliminary objection, insisted that the claimant's suit is caught by Section 16 of the Limitation Law of Cross River State. The suit having not been filed within 5 years as required by law, since the claimant cause of action arose in May 2008, and this suit was filed on the 12th day of April 2021, a period of over 13 years. The claimant, on his part, is of the view that the present suit cannot be affected by the Limitation Law of Cross River State, since the action was initially commenced at the High Court of Justice of Cross River State within the period allowed by law. The claimant argued, while relying on the case of CPAX Nigeria Limited, MIG4 Nigeria Limited, SUFRA, the Supreme Court has instituted a new regime regarding statute of limitation, a restoration of action that was filed within the period allowed by law, but was for one reason or the other struck out by the court when the suit is repealed, as was done in this case. The statute of limitation becomes inapplicable. The counsel for the defendant has tried hard to distinguish the case of CPAX and the present suit, in that, according to counsel, the facts of the two cases are not the same. Therefore, CPAX case will not apply to this case. The purported distinguishing, as attractive as it looks, is based on an illusion and a misconception. In CPAX case, the matter was filed at Federal High Court and it was heard. It was determined in favor of the claimant. On appeal to the Court of Appeal, the decision of the trial court was affirmed by the Court of Appeal. However, on further appeal to the Supreme Court, the suit was struck out on the ground that the Federal High Court lacked the jurisdiction to entertain such suit. Consequently, the claimant commenced a press action at the appropriate court, High Court of Lagos State. The defendant challenged the suit on the ground that the suit was statute bar. In its ruling, the High Court of Lagos ruled that the action was not caught by Limitation Law of Lagos State, which is immaterial with Section 6 of the Limitation Law of Cross River State. The Court of Appeal upheld the decision of the Lagos High Court. On further appeal to the Supreme Court, the Supreme Court upheld the decision of the lower court and concluded that where an aggrieved person commences an action within the period prescribed by the statute, and such action is subsequently struck out for one reason or the other without being heard on the merit or subjected to an outright dismissal, such an action is still open to be recommenced at the instance of the claimant, and the limitation period shall not count during the pendency of earlier suit. In other words, computation of time during the pendency of an action shall remain present from the filing of the action until it is determined or abate. In this case, a similar scenario played out. The case of the claimant was struck out by the trial court for lack of jurisdiction, and the Court of Appeal affirmed the striking out that it is only this court that has jurisdiction over the claimant's claim. In view of the circumstances of this case, I have no doubt in my mind that the claimant action is not affected by the period when the claimant instituted an action at the High Court of Cross River State, which went to an appeal, and ultimately judgment was rendered by the Court of Appeal in 2021. Therefore, the filing of this suit before this court is not statute bar, since the case was initially filed within the period allowed by the law. Law are procedural and strictly irrespective of a course of action, it cannot generally be broken. However, like every proposition of law, there is exception to the rule. Example of the exception to the general rule of limitation of action. In view of the foregoing analysis, it is my view that the suit falls within the exception to applicability of limitation law as postulated by the decision of the Supreme Court in CPAX Nigeria Limited versus MIPO, as the limitation period was present. During the period, the claimant's case traveled from the High Court to Court of Appeal, and the repiling of this case before this honorable court. The objection of the defendant failed in toto, and same is hereby dismissed for lacking in merit, with cost of 100,000 naira granted in favor of the claimant against the defendant. Give me date.
129.
You say?
29 June.
Okay.
July 6th.
This case is hereby adjourned to 6th of July 2023 for hearing. Yes. You say?
There's a matter that is not going on because they filed a motion.
Which matter is it?
One of the matter on the list is not going on because they filed a motion.
Number NICN CA292020 between Reverend Prophet Idigbe John and 1, University of Calabar. 2, the Governing Council, University of Calabar. 3, the Registrar, University of Calabar. My Lord, the claimant is absent, the defendant. Then your name is Esson and you Your position. Legal officer of the defendant.
Representation, appearance. Yes. Yes.
Journalists at war. Yes, we share operates. Lord, appearance is for the defendant.
Uche with Uche.
Operates. O-N-W-E-Z-E. With
Yes.
you graciously granted us a short adjournment with number of five at the end.
Yes.
Lord, five at the end. We can move there. Five within your notice project or and then you can take an adjournment for here. What the people for the part of 1990 people look at the end of each other.
Dr. Ebo, any objection? Give me this.
This is still false.
Which
This is 6th of June.
just leave this one off. Pass this. The application is granted as read. This case is hereby adjourned to 11th of July 2023 for hearing. Call the you say 11th of July. July 11th for hearing. Yes, call the next.
Mr. Samuel Michael Iwan and Asian National Nigeria Limited My lord, the claimants is in court, the defendants are absent.
Appearance? Yes. Yes. Yes.
Maybe,
Yes.
my lord.
Yes.
Maybe Joseph Abukpai, my lord. Joseph
Joseph.
Abukpai. Abukpai. Abukpai spelled ABU
Yes.
KPAIN.
Mhm.
ABU KPAIN. I appear with my learned friends, my lord. IA
who?
Adelupe, my lord.
Ade.
Adelupe. ADELUPE, my lord. ADELUPE.
Yes.
And OD initial Aderibigbe. OD Aderibigbe.
Aderi baby.
Yes, Aderibigbe is ADERIBIGBE, my lord.
Yes.
We humbly appear for the defendant applicant, my lord.
Yes. Yes.
My lord, we have before, my lord, an application, my lord, to regularize our defense.
You have application. Have you served it on the claimant?
Yes, they've been said, my lord, for long.
When was it filed?
It was filed
When was the application filed?
my lord, it was filed on 18th of August, 2022.
18th of August.
2022 is dated 5th day of August and filed on 18th of August, 2022.
Is this the one for extension of time?
As the copy is this. It's an application to further extend time.
Mr. Ofe, have you been served with that application? You say? Yes, the one filed on 10th of August. It's dated 5th of August, filed on 10th of August. Have you been served? Any objection? You say?
I'm saying that we then thinking that matter will not be offline, will not be online.
But that was what, when this matter was adjourned, the court say it's going to be virtual.
So when our client complained, we got the number that was included in the text message given to us, and we had to come with it to make the complaint. That's why we are here. Because we
To make which complaint? Where were you when this matter was adjourned today for virtual? Where were you?
text message.
No. On 7th of December 2022, claimant in court, defendant represented by Emmanuel Oguchi Adeto, then Joseph Abukfai, Esquire for the defendant, claimant, my lawyer is sick. Abukfen, the defendant's counsel, the defendant and counsel for the defendant are all resident in Lagos. I came all the way from Lagos, and counsel for the claimant is not in court. In view of the distance, we humbly apply for this matter to be conducted virtually. In view of the observation of counsel for the, this is what the court says, in view of the observation of counsel for the defendant, this matter will, as from the next adjourned date, be conducted virtually. However, counsel who can attend physical hearing is free to do so. This case is hereby adjourned. So what complaint do you have? You were not in court. You refused to come to court. Your client was in court when the court made an order that this case would be conducted virtually. What is the problem for you conducting it virtually? And the court say you are free to attend physically and you are here physically. So what is the problem?
For instance, you have a motion that said defendants, for the reason that they have not.
They did what?
Said we made a motion which we ought to accept on the defendants for the reason that they have not provided us with a service address here in Calabar as in compliance with the rule. And also,
Yes.
so the subpoena. Wanting them to produce before the court a signed copy of a letter of employment that was meant for the claimant, because what they gave to him was not signed. And they are not here. You may have it.
Does that have any effect on the case?
That's copies.
It will be that we go on. And the defendant, a claimant cannot produce a signed copy of the letter of employment.
Must employment be in writing? Must employment be in writing?
That's copies.
If they don't want, my lord, then we have to follow that procedure.
It's all right. That is not a problem. Mr. Abukfai,
My lord,
counsel has complained you have not supplied your address in Calabar for them to serve you. They have processes to serve you, and because you have not provided your address in Calabar in compliance with the rules, they could not serve you.
as copies. My lord, we're very sorry about that. We're going to supply our address. My lord, I'm aware that they filed an application 2 days ago, my lord. The application is to contest this defense. And I wonder why the claimant, my lord, will choose to want to stall their own matter. My lord,
It's
my
left
lord,
for them now.
as copies. With my
It's
lord,
left for them if they want to stall their matter.
as
Is it
copies.
their own matter? Is their
My
own
lord,
headache?
Not
Yes.
to take my memory lane. My lord, the first time we're in court for this matter, we had an application to regularize our
Also,
defense.
you can sit down, talk while sitting, so that we can hear you very well.
Great for my
So that
lord.
you'll be close to your.
As copies.
Yes.
So, my lord, we had an application to regularize our defense. The
Yes.
first time we came to court, my lord. That was the first defense we filed in this matter. The first statement of defense we filed in this matter, which is dated, my lord, I think 27th of January 2021. That was the first defense. But my lord, we omitted to exhibit the defense to the application to regularize. My
Yes.
lord. So my lord directed that we should file another defense within 7 days.
Yes.
My lord, my lord gave an order which we are bound to comply with, my lord. But
Yes.
even after proceedings, I spoke with the counsel for the defendant. We thought maybe my
Yes.
lord must have felt that application was an application to amend our defense. My lord, usually in practice, we learn every day, my lord, but usually in practice, we don't exhibit the statement of defense because it's already filed. And what the application is saying is, my lord, help us deem this application has been, and this defense has been properly
Mr.
filed.
Abukfai, let us not waste time. Let's go to the business of the day.
It's copies. I'm just trying to lay foundation because I will need to withdraw a particular defense which we filed after that. Because after we brought that, after the court gave that order, we filed on the 7th day according to the registry. Well, my learned friend raised another objection and brought an application challenging the second statement of defense that we filed on several grounds. So we said, okay, since these are things that the claimant could have overlooked, but since they want to stall their matter, let us refile another statement of defense. And it wasn't like we were out of time, my lord. We filed on the 7th day because my lord said we should file within 7 days. So by the calculation of the registry, we filed on exactly the 7th day. So, but when we discovered that, we now said, okay, to stop all this to stop in furtherance of the challenge, let us just withdraw this application and this defense and file another one. That's why we have the third defense, statement of defense, that is dated 10th of August 2022. And that is what the claimant is seeking to challenge now, that we have 3 statements of defense before the court. That's the application they have filed the first day, saying it's an abuse of court process. None of the defenses, statement of defense is before the court as we speak. None of them, because we have not regularized any of them. So the application we have this morning, my lord, which is the application that we've drawn my lord's attention to, filed on 10th of August, is to regularize this defense that filed on 10th of August and withdraw the earlier defense that was filed on 17th of March 2022. My lord,
To withdraw which application?
to withdraw, no, the statement of defense. To withdraw the statement of defense dated 17th of March 2022. We applied to withdraw the statement of defense dated 17th of March 2022.
Yes.
And to take the application, my lord, to regularize the
Wait,
statement
one
of
by one.
as copies.
Mr. Open is applying orally to withdraw statement of defense filed on the 17th. Any objection? What is that you have filed? Mr. Open, don't waste time of the court. Don't waste the time of your client. The law is clear. When there are 2 applications, one is to regularize, one to do away with the thing. You take the one that will solve the problem.
As copies.
He said he is applying to withdraw his statement of defense. Are you objecting? On what ground are you objecting?
As a copy.
Mr. Ofem, I said we will take them one by one. He said now he wants to withdraw that of 17th. Are you objecting to that one? Why can't he take? Why should you waste my time? You came to court, you are the claimant. Somebody wants to bring his defense and we should shut him out. What is the problem in allowing them to come in to regularize their position so that the matter can be heard on the merits?
As copies.
Are you objecting or are you not objecting? I want to. The oral application of counsel to withdraw his defense filed on the 17th day of March 2022 is hereby granted. The said statement of defense is hereby struck out.
As copies. I'm very grateful, my lord.
Yes, which other one?
The next application is dated 10th of August 2022, my lord. 10th day of August 2022.
I'm coming. Tenth of August
2022, my lord.
Yes. Yes, what do you want to do with it?
But it's brought pursuant
Yes,
it's brought pursuant to order 57, rule 4, sub 1 and 2, and order 17, rule 1 of the rules of this honorable court.
Mr. Open, have you been served with this application? Have you been served? Motion on notice that was filed on 10th of August. Have you been served?
Yes.
Are you objecting to it?
Yes, we are.
He said he wants the extension of time.
Because we are saying that it is the perpetual habit of filing various statements of defense of applications in order to frustrate them.
Mm.
In 2020, and
So if we refuse to allow them to come in, so we should allow you alone to.
my lord, we currently have a motion with 5 years ago, complaining that they have committed duplicity of suits. So they have 3 pending statements of defense at the same time, by the same parties on the same subject matter in the same court, in abuse of process. And
Which other, what are the applications that are pending, the 3 applications?
I'm saying,
What are the 3 applications? Tell me,
I'm talking about statements of defense.
which and which? Which and which?
One was filed on the 27th day of January 2021.
27th day, what happened to it?
It was pending, they went ahead to file another one on the 17th day of March 2022.
We don't have that one again. We have struck it out.
As God pleases.
Saying that
Mr. Abupai, they say you have another application, you have another statement of defense filed on the 27th day of January,
My lord,
27th January 2021.
my lord, that application has been taken. That application was taken, and my lord directed.
Is
that
there
we should-
any you have application in respect of that?
No, it's an application to regularize defense.
When
we filed.
was the application taken?
My lord, it was taken on.
He said that the application has been taken. There was an application to regularize. So tell me when was that application taken?
Well, it was taken on either 27th or 28th. I'm trying to get my record of that January. The first time we're in court, my lord, that application was taken.
The first time this case before me was 12th of October 2021. 12th of October 2021, claimant in court, defendant absent, claimant. I tried to reach my counsel, but to no avail. In the circumstances, I need time to get in touch with my counsel. This case is adjourned to 1st of December 2021 for hearing. Hearing notices to be issued and served on all the parties. That is what transpired on 12th of October 2021. Then on 1st of December 2021, claimant in court, defendant absent, CI Anyau Esquire for the claimant, Joseph Abukpae for the defendant. Anyau, I hereby apply for an adjournment to enable the defendant regularize their processes. Abukpae, we have filed memorandum and statement of defense, but we realize we are out of time. This case is hereby adjourned to 8th of March 2022 for hearing. on 8th of March, claimant in court, defendant absent, James I. Opem Esquire for the claimant, Abuk Fai for the defendant. Abuk Fai, this matter is for hearing, but I have just been served with a reply. I need time to go through it so that I will be able to cross-examine the process. Abuk Fai, we have motion on notice dated 15th of February 2022, filed on the 17th day of February 2022. The application for extension of time to file depends out of time. Mr. Opem, no objection. Ruling, I have the application was granted. The defendant is hereby granted 7 days within which to file a statement of defense out of time. This case is hereby adjourned to 25th day of May 2022. It is for hearing on 25th day of May.
No, my lord, that was the day the application. My lord, that's the application. That's the application that was taken that day, 15th of February. The application was taken and granted, my lord. That's the application they are referring to.
It's not 15th of February, it's 8th of March 2022.
8th of March. Oh, apologies, my lord.
8th of March 2022. Mr. Open, what is your problem now? Having heard that the court has taken the application and has granted them to file, granted the 7 days. Mr. Abupai, have you complied with the order of the court?
No, we didn't comply. That's why we have this application to further extend time. What we are praying here, and we have paid the necessary default penalty. So what we're praying for is to further extend time.
You did not file within the 7 days.
We filed within 7 days. That was what I was explaining to my lord. We filed according to the registry's calculation. But because the number of days.
Listen, you know the court on 8th of March gave you 7 days. Would you wish to file statement of defense? Have you complied with that order?
No, my lord, we didn't comply.
So
we have an application.
Which application is that?
Which is the application dated 10th of August 2022. The one we're trying to take.
Okay, now, Mr. Ofen, on 8th of March, the court granted their application to file that statement of defense, which was 27th of January. The application was filed on the 17th day of February 2022. The application of 17th of February 2022 was granted on 8th of March 2022, which court now said, okay, they were asking for the court to deem that their defense, which they have already filed, as properly filed and served. But the court said, no, I gave you 7 days within which to file statement of defense out of time. So based on that, I don't know, I asked him whether he has complied. He now confessed that he has not complied with that order. That's why he is coming by this application of 10th of August to seek for extension of time to comply with that order, which the court said they should file their defense within 7 days. So he's now asking the court by this application of 8. So what is the problem now?
Like you said, we have 3 statements of defense standing now.
Mr. Opem, look, he filed application he filed his statement of defense on 27th of January 2021. He filed it out of time. He did not file any application for extension of time as at that time. But he now brought an application on 22nd of on 22nd of February 2022 for him to regularize that statement of defense of January. The court on the 8th of March took the application. You were here and you said you are not objecting.
That's copies.
Yeah? Have you seen it? Yes, that is the application which was granted on 8th. Eh?
Yes, ma'am.
The application is dated 15th of day of February and it was filed on 17th.
Yes, ma'am.
And that was the one that was granted on 8th of March. And on that day, they asked for deeming order to deem what they have already filed, which means the defense of 17th of January 2021. That's what this application is asking to deem, but the court say no, we are not deeming that application. Would go and file a fresh statement of defense. But they have not complied with that order of the court. According to them, they filed another statement of defense on 17th of March. But you know, 17th of March, they are out of time because they were only given 7 days. So they have now withdrawn that statement of defense, meaning there is no statement of defense now pending before the court. They are now bringing this application of 10th of August for them to comply with the order of 8th of March. I hope you are getting it now. Mr. Open, don't waste our time. So many counsel are waiting, please. Which one do you have? The one they have is 10th August 2022. That is the one they want to move now. Yes, that is the one they want to move now. Are you objecting to it? Are you objecting to it? First of November. Let me see it because it's not in my file. Hey, collect it. Let me see. 1st of November. This one is not concerning statement of defense, Mr. Open. Give him, let him look at it. Read the press. It's not concerning this statement of defense he wants to now bring in. Yes. Okay. The application is granted as prayed.
Okay.
As copy.
As
So
copies.
what next? What next, Mr. Abukpai?
My
You
lord,
have
we have,
now regularized your position. Which other application do you have?
my lord, we have an application to substitute our witness.
Mr. Open, there is another application now, the one you were mentioning, 1st of November. He said he wants to move it. Are you ready? Have you been served? Are you objecting to it?
My lord, subject to the court's convenience, we'd like to move in terms of our prayers in the application, my lord.
The application is granted as prayed.
As copy.
Very good.
So what next, Mr. Open? Yes, Mr. Abupai,
My lord,
you should within 7 days file your address within the jurisdiction of the court, address of service in compliance with the rules.
as copies, as copies, we will do that. And we're sorry for any inconvenience that must have caused my learned friend, my lord.
Yes, Mr. Open. What would be the position of your application of 16th May? We humbly apply to withdraw motion on notice dated 16th of May 2023 and file on same date. Mr. Abupai, are you objecting?
No objection, my lord.
the motion on notice dated the 16th day of May 2023 and filed on the same day is hereby struck out for having been withdrawn without objection. Yes, now you want to react to the defense now. You want to react to the defense. Give me this.
My lord,
Yes,
my lord, we're considering that since this proceedings today is virtual, and
yes,
if they file their reply, it means that the matter will be ready to go on for hearing. My lord,
yes.
if my lord is inclined to take all witnesses on the same day, we can come to Calabar if we're sure that proceedings will go on, so that all parties and counsel can be present in court, my lord, subject to the court's convenience.
Yes, it depends on you, counsel, now, not the court. It's you, counsel, that if you want that, it can happen.
My lord, if
Or
my
we find 2 days for you, so that those 2 days we finish everything, whatever happened on the next day. If we couldn't finish, we continue on the next day,
as copies,
so that you bring all your witnesses within those 2 days.
as copies.
Yes, registrar, give me 2 days. 12th and 13th. So, Mr. Open, whatever you want to file it within time and submit on council, so that at the next adjourned date, we take all the witnesses within those 2 days we are giving you. This case is hereby adjourned to 12th and 13th day of July 2023 for hearing.
As copies. We're very grateful, my lord. Much
You are welcome.
Number FICN 11/2023 between Idigbe Iwa Adewale and Clinton Brown, 2, Natural Nature
Renaissance International Limited.
Renaissance.
Yes, thank you, counsel. We have finished with the virtual sitting. You can leave.